الآن ننتقل إلى القانون الدولي والفضاء السبراني، والكلمة الآن للأمين العام، فليتفضل مشكورا.
Mr. Vice President, distinguished delegates, ladies and gentlemen, ALCO's engagement with this topic, namely international law in cyberspace, emerged in the context and with the proposal from the People's Republic of China way back in 2014. Since then, the topic has been on the agenda of ALCO every year, with its significance growing each year. It's important to mention that our discussion on this topic here in Dar es Salaam will be taking place in the backdrop of the just concluded fourth meeting of the Working Group on International Law in Cyberspace, concluded in Hangzhou, China, from the 2nd to 4th September 2019. We are pleased to have invited Rapporteur on this topic, Professor Wang of Wuhan University Law School, People's Republic of China, who has been engaged to work with this topic in order to iron out some of the more complex dimensions of the subject. On this note, I once again congratulate the People's Republic of China, the Rapporteur, and each of our member states for their active interest in this topic. It is important, Mr. Vice President, to note that the topic of cyberspace has attracted big attention from our member states. It is on this note that in this session, we have invited Special Rapporteur, together with one expert, Dr. Zakayo Rukumai, to initiate and assist deliberations in their capacity as experts. While Dr. Zakayo Rukumai will present in his capacity as expert, accordingly, he will present in his individual capacity. I therefore wish to invite first our Special Rapporteur, Professor Wang, to make necessary presentation which will relate to his ongoing work as a Special Rapporteur on this topic. Professor Wang.
Okay. Thank you, Mr. Secretary General. Mr. Vice President, is it on? Okay. Distinguished delegates, during the fourth meeting of ALCO's Working Group on International Law in Cyberspace, held in Hangzhou, I briefly reported how the member states responded to the questionnaire on cybercrime I have prepared. Today, it's my great pleasure to present a slightly updated report for your deliberation. During the 57th annual session of the ALCO held in Tokyo last October, one of the decisions made by the member states is for me, quote, to prepare a report on the latest development on international law in cyberspace and on the special need of the member states for international cooperation against cybercrime, end of quote, in my capacity as a rapporteur of the open-ended working group on international law in cyberspace. So how to prepare the report, in particular, how to understand the special need of the member states for international cooperation against cybercrime. After consulting the Secretariat, I started from preparing a questionnaire for the member states. It included 4 parts, that is domestic law, international cooperation, capacity building, and technical assistance, and public-private partnership. There were 38 questions in total. The questionnaire was sent to the member state by the Secretariat on March 29th this year. And by the end of August 2019, 11 replies had been received from the member states. These countries were Oman, Myanmar, Iran, Korea, Japan, Bahrain, Malaysia, Kuwait, China, Ghana, and Thailand. Most of the replies were organized according to the 38 questions in the questionnaire. A few member states chose to offer their views on the 4 parts of the questionnaire in a more general way. But all these replies provided a useful source for understanding the special need of ACOR's member states for international cooperation against cybercrime. Below, I will try to summarize the key message I see in the replies. In terms of domestic law on cybercrime, most, that is 8 out of the 11 countries, confirmed that they had already formulated or amended such domestic laws, and most of them had the same or similar views on the basic issues relating to the substantive law of cybercrime, including conviction and sentencing. So for example, the domestic laws of all the replying member states involved offenses related to infringement of intellectual property, and except for one member state, all the others had domestic laws involving the criminal form of cybercrime, such as complicity attempts. The states were more divided on the issue of investigation and electronic evidence, that is, whether the domestic laws included procedural law of cybercrime. Actually, out of the 10 countries which replied to the question, 5 answered yes, while the other 5 answered no. And also on provisions on electronic evidence, this time 6 countries answered yes, while 4 answered no. Member states emphasized the vital importance of international coordination in this area. One state made the point that strict precautions were required when a police forensic team or a computer expert was contracting electronic evidence. Another state provided detailed explanations on possible rules addressing various aspects of capacity for collecting electronic evidence, methods of collecting electronic evidence, admissibility of rules of electronic evidence, and transborder access to electronic evidence. The second part of the questionnaire on international cooperation witnessed the different attitude of the replying member states on most questions. The number of states which had joined the Budapest Convention on Cybercrime, the agreement on cooperation in ensuring international information security between the member states of the Shanghai Cooperation Organization, and the League of Arab States Convention, respectively, was one, while 8 states suggested that they had not joined any cybercrime conventions. 4 states joined the 24/7 cooperation network of cybercrime, and 6 did not. The 4 states had signed, altogether 4 states had signed bilateral cybercrime treaties, and 3 replied no. Only 1 state confirmed that its domestic law included regulations concerning transborder access to data for criminal purposes, while most other states did not have such regulations. On the question of Article 32B of the Budapest Convention, 1 state was in support of this article and 1 state was against it, while most other states did not make clear their positions. All the member states indicated that they had conducted law enforcement cooperation and legal assistance concerning cybercrime with other countries, and most appeared to view the function of existing legal assistance and law enforcement cooperation framework in combating transnational cybercrime as not fully satisfactory, but they differed as to how this cooperation framework should be improved. The member states were able to reach more consensus on the issue of capacity building and technical assistance. All of them were of the view that capacity building and the technical assistance for combating cybercrime were necessary, and they all recognized the need to set uniform standards for combating cybercrime technical assistance. Most states had received technical assistance related to cybercrime and cybersecurity from other states or international organizations. Also, most states provided detailed and practical suggestions as to how capacity building could be strengthened in terms of personnel training, critical information infrastructure, and some other aspect. Regarding the last part, that is public-private partnership, all member states agreed that it was beneficial to combating cybercrime, and they offered helpful but sometimes different views on such issues as the qualified private entities, the scope and the means of private entities' investigation, etc. One state made the point that a sound legal basis is indispensable for the development of public-private partnership. To conclude, while showing a degree of difference on many specific issues, such as suggestions for international coordination in domestic law and attitude towards Article 32B of the Budapest Convention on Transborder Access to Data, most member states replying to the questionnaire indicated the need for enhanced international cooperation in combating cybercrime and for the strengthening of the capacity building and technical assistance in this regard. Looking ahead, further input from ACCO member states on this topic will be most sincerely welcomed so that I can further develop my report based on the mandate of the ACOR. With this, I finish my report. Thank you for your attention.
Thank you very much, Professor Wang. It's now my honor to invite the second expert, Dr. Zakayo Rukumai, who is also the principal of the Law School of Tanzania. I'm informed that he will use the podium because he wants to use some sort of technologies.
Honorable Vice President, Honorable Secretary General, distinguished delegates, I take this opportunity to thank ALCO for giving me this opportunity to give a presentation on how international law principles can be applied to cybercrime. So As I said, the purpose of this presentation is to examine how international law principles can be applied to cyberspace. And those principles are those related to international cooperation, sovereignty, jurisdiction, and the law of armed conflicts. The nature of cyberspace is such that it is global in nature. It crosses border. And cyberspace refers to the global network of independent information, technology infrastructures, communications, networks, and computers processing systems in which online communication takes place. This global network, that is the internet, has made it possible for individuals to interact, exchange ideas, share information, provide social support, and conduct business. But in view of the anonymous nature of the internet, it has been possible for criminals to engage into a variety of criminal activities in the cyberspace. And such cyberspace has become a new area of conflict between nations, and cyber attacks are now becoming prevalent, creating chances of engaging in a war. The present state of internet has created a necessity for a system of laws and regulations referred to as cyber laws. Different countries are adopting their own strategies to face the challenges posed by cyber criminals. And on cybercrime, the increasing sophistication and speed of computer systems and the convergence of information and communication technologies enhance the capacity of technological change to benefit society, but also provide opportunities for those who seek to exploit the same capacity for criminal purposes. Cybercrime is not a defined legal category, but a label that has been applied to a range of illicit activities associated with information and communication technologies and computer networks. Cybercrime is a crime committed using a computer as a target or tool. I must say that there is no agreement so far in many countries as to what would constitute a criminal conduct for it to be outlawed. It appears that each country would define a cybercrime depending on its own interests and depending on its own politics, and it depends on their constitutions as well. It happens that what is a cybercrime, for example, in Tanzania, is not a cybercrime elsewhere. And as we'll see later, this brings complications and challenges when you want to enforce the laws or these cybercrime legislation. In Tanzania, we have an act of 2015 which criminalizes a number of activities, illegal access, illegal remaining, quite a number of them. But the reason I included this is to show that many crimes, offline crimes, can now be committed using computer networks. At the end of the day, you may not have what is called cybercrimes, but you just have a topic of crimes, and cybercrimes would be just a subtopic in the larger set of crimes. And because these have the effect of threatening lives and properties, disruption of critical services, terrorism, and economic sabotage, as well as propaganda and theft of information. In Tanzania, for example, when an offender is found guilty, he may be condemned to a jail term or a fine or compensation or all the above, depending the offense. The heaviest sentence under the Cybercrime Act of Tanzania is imprisonment for not less than 7 years and a fine of not less than 100 million. But I also included this to throw a challenge that this piece of legislation, as many other pieces of legislation, is country-specific. Each country, as I said, determines what activities in the cyberspace should be outlawed. Tanzania, for example, has decided to punish dissemination of false information. But also international cooperation, when you have these kinds of country-specific pieces of legislation, international cooperation becomes a challenge. And here I call for countries to agree on harmonization of their pieces of legislation. In other words, to agree what activities should be criminalized and what activities should not. And I'll move to, in the absence of this agreement on what would constitute a cybercrime, I would propose application of international law for the reason that the internet is global. In other words, it has the global reach. It is possible now for computer crimes to be committed from outside borders of a country. As such, cyberspace has changed the established criminal law, which is purely domestic. Transnational criminal activities need appropriate legal instruments. The solution seems to be that cybercrimes challenges should be addressed by an international law through the adoption of a binding international legal instrument. treaties, conventions, customary, international law, and general principles, as well as scholarly opinions. But key issues arise as far as this international approach is concerned. When you have a cyber attack, for example, the question would arise as far as the internet is concerned in relation to its governance. The question is, who governs the internet? So aspects of global governance comes in place, sovereignty of states. Each state would have its own control on its infrastructures, online data, cyber activities, and governance of the internet within its own jurisdiction. But you also have a challenge on online freedom, but also you have a challenge on how the law of armed conflict can apply to cyberspace. But as well as you also have a challenge revolving around international cooperation in combating criminal activities. I propose that we make use of Article 19 of ICCPR. A state may exercise extraterritorial jurisdiction over cyber activities pursuant to this Article 19, because the state has the right under the international law to defend itself against any cyber attack threatening its national security, public order, or the lawful rights and freedom of others, including the rights of privacy as well as intellectual properties. I'd also propose that we use the universal jurisdiction theory, and in this, a country can invoke universal jurisdiction when the offense has the international character, like piracy. Cybercrime has international character, as I said, and I propose that universal jurisdiction theory can apply. When you read my long paper, you will see the challenges that I posed as far as using universal jurisdiction theory, and this requires some consensus between between countries. But there's also the Budapest Convention at Chapter 23 can be used for international cooperation. The problem with this is that this is not an international kind of an instrument, and as such, it cannot resolve all issues as far as jurisdiction is concerned. Because the way it is worded, it depends on the goodwill of a country that you seek cooperation from. The convention is also short on giving states the necessary weapons to fight cybercrime. But on cyber terrorism, I propose the use of the Rome Convention of 1988. It can also be defined or interpreted to cover cyber activities. On cyber warfare or cyber war, the question is whether the principles of jus ad bellum can be applied to a cyber attack, and you have the answer from Article 2, Subarticle 4 of the UN Charter, which refers you to Article 51 of the same charter. Now, my question is, can Article 51 of the United Nations Charter be invoked for a country which needs to protect itself against cyber attacks? There is a general consensus that the law of armed conflict can be applied to cyber attacks, particularly when destruction of its infrastructure or critical infrastructure is made, like railways, banks, etc. But the question is cyberspace a battle space between nations? Is it physical? In a war, in a physical war, in a conventional war, you know where the enemy is coming from. But in cyberspace, you may not know where the war or the enemy is coming from. Now, the question is whether international law principles can be invoked to address cyber attacks. Another problem is it is difficult to attribute a cyber attack to a state when it is done by an individual. You cannot with certainty say that this individual has been sponsored or has been sanctioned by a certain state in order to invoke the principles of international law. Another problem is, how can you attribute an attack or a cyber attack to a certain country? It just becomes a speculation that this attack has come from this country. I know from the technical point of view, you can locate the root of you can locate the source or the root where the attack or the cyber attack comes from. But it is risky to invoke principles of warfare in a cyber attack in view of its anonymous nature and lack of certainty as far as the sponsorship is concerned. But there's also another problem. Some infrastructure, as far as the internet is concerned, is owned by a private person, private companies, private parastatals, and they are not owned by the state. Now, to attack a country simply because its individual or its citizen has launched a cyber attack to a certain country, that becomes a little bit challenging. These questions call for a more dialogue to determine how the law of armed conflict can be extended to cover cyber crimes. In conclusion, I insist that international crimes are international, and because they're international, they have the tendency of crossing borders. It needs an international solution. There is need for an international binding instrument under the auspices of the United Nations. I underline the auspices of the United Nations because that is the organ which many countries agree with. The Budapest Convention is not, much as it has gained an international recognition, but it was not made under the under the auspices of the United Nations. And because cybercrime conventions can be overtaken by technological advancement, there is need to have a technological neutral legal instrument. On international cooperation, I advise that there should be an agreement on what activities should be outlawed, and harmonization would be one of the steps towards international cooperation. Again, application of modern technologies should be employed to curb cyber attacks, and ARCO countries may borrow a leaf from China. Asanteni sana.
شكرا على هذا العرض القانوني. والآن نفتح باب النقاش، والآن الكلمة لممثل كينيا فليتفضل.
Thank you very much, Mr. President. Thank you for the opportunity to make the following brief statement on behalf of the Republic of Kenya on this important agenda item on international law in cyberspace. Distinguished delegates, Kenya recognizes the critical role that cyberspace plays in the global economy, and that it has national and international dimensions that transcend industry, commerce, intellectual property, security, technology, culture, policy, and even diplomacy. It's acknowledged that cyberspace is a unique phenomenon with distinct characteristics, and that new and emerging technologies, which are expected to change and improve many fundamental tasks and interactions in coming years, such as artificial intelligence, blockchain, Internet of Things, quantum computing, among other things, present significant opportunities for the global community at large. However, it is also acknowledged that challenges have emerged with these technological advancements, and there is need to urgently address the lack of international norms to address the emerging issues or to address the threats attached to the use of cyberspace. Distinguished delegates, that is why the ongoing work within the auspices of ALCO to encourage member states to deliberate on matters pertaining to emerging international legal issues on cyberspace is important. We therefore note with appreciation the efforts of the ALCO Secretariat, as well as the open-ended working group, and in particular, the efforts in identifying the challenging issues of international law, which include and are not limited to the application of the principle of non-interference in cyberspace, data sovereignty, and data security. We recognize their efforts in tracking the latest developments in international and regional platforms on this topic, and in beginning to develop consensual basic principles of international law applicable to cyberspace. Distinguished delegates, Kenya acknowledges in particular the emerging legal issues surrounding the misuse of computers and cyberspace in general, and the need for an international framework in addition to existing regional frameworks to enhance cooperation in combating the transnational nature of cybercrime. In order to mitigate cyber threats and to foster a safer Kenyan cyberspace, Kenya has taken considerable steps to develop strategies and to strengthen its domestic legal framework to address these threats. To curb cybercrimes and to mitigate the threat of cybersecurity, Kenya has enacted the Misuse of the Computer and Cybercrimes Act of 2018, which has the following objectives: to prevent the unlawful use of computer systems, to facilitate the prevention, detection, investigation, prosecution, and punishment of cybercrimes, to protect the rights to privacy, freedom of expression, and access to information as guaranteed under the Kenyan Constitution, and to facilitate international cooperation on matters covered under this Act. To enhance international cooperation in combating or countering cybercrime, the provisions of the Misuse of Computers and Cybercrimes Act complement Kenya's existing legal framework for mutual legal assistance and extradition. This therefore allows for international cooperation in case investigations, information, and intelligence sharing in any criminal matter with requesting or requested states for purposes of criminal proceedings concerning offenses related to computer misuse and cybercrime. Distinguished delegates, the enactment of the Kenya Information and Communications Act of 2015 has gone a long way in strengthening the multi-agency collaboration framework which supports Kenya's national cybersecurity resilience. The National Coordination Agency detects, prevents, and responds to various cyber threats targeted at Kenya and acts as the interface between local and international information, communication, and technology service providers whose platforms are used to perpetrate cyber crimes, and our judicial, law, and order sector, which investigates and prosecutes cyber crimes. Mr. President, to conclude, Kenya applauds the work of the open-ended Working Group on International Law and Cyberspace and assures the group of its continued support for the same. We do confirm that we are in the process of preparing detailed responses to the questionnaire to contribute to this ongoing dialogue, and these will be submitted to the ALCO Secretariat very shortly. I thank you, Mr. President.
شكرا لممثل كينيا. والآن مع كلمة ممثل تنزانيا، فليتفضل مشكورا.
Mr. President, Vice President, it should be noted that the cyberspace is not and should not be a lawless area where anyone can conduct hostile activities without rules or restraint. Otherwise, the cyberspace will end up being an anarchist area. The United Republic of Tanzania is in agreement that the cyberspace is subject to principles of sovereignty and jurisdiction, as well as prohibition on interventions in the affairs of other states and the use of force. States have the right to apply countermeasures to either bring about lawful situation or de-escalate an unlawful situation in the cyberspace. Such countermeasures may be physical or anti-access and areas denial or denial operations aimed at, for example, at preventing aircraft landing or overflights. States could lawfully undertake a denial operations as a countermeasure against the malicious cyber activity until it receives compensation from harm. From the above, the United Republic of Tanzania recommends the following. There should be an international legally binding instruments to regulate cyberspace. Moreover, there is a need to establish clarity on the role of international law in cyberspace activities, since some states have begun disseminating their own interpretations of international law with regard to cyberspace. Second, also there is a need to determine whether existing law is sufficient or satisfactory to provide sufficient guidance and guarantees for states' relations in the area of cyberspace. Third, there is need to clarify or to classify cyber attacks that qualify as violations of international law. And fourth, there is political will of major cyber powers to discuss red lines for offensive cyber activities need to be addressed. Fifth, the application of international law to cyberspace need to be clear with respect to humanitarian cost of cyber attacks, especially when some organizations use cyberspace for communication and logistics that have been a subject of cyber attacks. And lastly, there must be multilateral response to existing emerging threats in the cyberspace areas. Mr. Vice President, those are the views from Tanzania.
شكرا لممثل تنزانيا. والآن مع كلمة ممثل نيبال.
Mr. Vice President, Your Excellencies, Ministers and Ambassadors, Mr. Secretary General, distinguished guests, delegates, participants and observers, ladies and gentlemen. Mr. President, the delegation of Nepal deeply acknowledges and appreciates the efforts for the development in the field of international law of cyberspace prepared by ALCO Working Group on International Law in Cyberspace. In fact, ALCO has endeavored to make a significant contribution to the development of international law of cyberspace. This approach has engrossed on the necessity to elucidate the norms of international law on cyberspace and a further expansion of these norms considering the new technological development. Mr. President, technology has resulted in significant changes, and international law has always been asked to deal those changes. New technologies raise new issues and questions. It is now generally held that international law applies to cyberspace, and the legal debate has shifted to how international law applies in cyberspace. We must articulate and build consensus around how it applies and consider from there where and what additional understandings are needed. All states, including ALCO member states, seek norms for cyberspace, but they have very different ideas as to the desired and state and the means to get there. However, a non-binding general document clarifying the constitutional basic principles of international law applicable by cyberspace will be vital. As a member state, Nepal has always extended its full cooperation in developing international law of cyberspace and enhancing cooperation in countering cybercrime. Mr. President, Nepal aims to address the challenges by creating institutional capacity within the country that monitor developments and provide related services, guidance, and information. In order to address the challenges of cyber security and issues of cyberspace, the government of Nepal has endorsed a bill on information and technology to the House of Representatives. Since cybersecurity is not a mere domestic deal, the global undertaking to countering cybercrime is emergent. Mr. President, Nepal is in favor of comprehensive and non-binding international instrument clarifying the constitutional basic principle of international law applicable in cyberspace. The resolution adopted at the previous annual session encourages us to make amendment of domestic law on cyberspace in line with the spirit of Budapest Convention. Sovereignty in cyberspace, governance of cyberspace, cyber welfare, and cyber crimes are the issues and areas that the international law on cyberspace has to deal with. And these concepts are very new to developing countries where necessary infrastructure and human resource regarding cybercrime are yet to be developed. Therefore, I believe a special measure has to be established to address inclusion and cooperation among member states to enhance cooperation in capacity building and set uniform standards of combating cybercrime. I would like to notify that Nepal is under a process of consultation with responsible authorities to contribute the special need of the member states for international cooperation against cybercrime. Finally, on this occasion, I would like to reiterate that Nepal wishes to place on record that ALCO should take initiation in the development of appropriate and effective rules of international law to combat cybercrimes and of an international regime and assist the international community for building robust mechanism and a modality and balancing between the state domain and public domain via wise development of secure and inclusive cyberspace. Thank you very much.
شكرا لممثل نيبال. والآن مع كلمة ممثل الهند فليتفضل.
Thank you, Mr. Vice President. On behalf of the Indian delegation, I take this opportunity to thank the ALCO Secretariat for the preparation of a detailed background document on the topic and in the introductory statement made by the Secretary General and the Special Rapporteur. Cyberspace, as we all know, is a complex domain that goes beyond our understanding of traditional domains of land, sea, air, and space, and its unique attributes presents its own set of opportunities and challenges. The increasing use of information and communication technologies has generated social awareness, accelerated economic development, improved delivery of services to citizens, and placed unprecedented power and information at the hands of an individual. The lack of borders in cyberspace and the anonymity of the actors has ensured that the traditional concepts of sovereignty, jurisdiction, and privacy are challenged. Taking into consideration the existing and potential threats posed to the international peace and security by the malicious use of ICTs, it is important to prioritize the need to have common understanding and implementation of important norms already agreed in the UNGGs. States should consider best practices to cooperate to exchange information and should encourage responsible reporting of malicious use of ICT. Even as technologies of active defense are developed, the attackers are several steps ahead. The classical form of ICT infrastructure-based jurisdiction is under reconsideration in terms of evolving nature of cyberspace environment to the data-based jurisdictional aspects. There is a need to develop better understanding of applicability of international law in cyberspace. Commitments of states under the UN Charter and other international law would apply to its behavior in cyberspace. However, the novel character of cyberspace and the vulnerability of cyber infrastructure have led to questions whether existing international law can provide sufficient answers to the emerging concerns in cyberspace. The working of the UNGGE reports so far do not clearly acknowledge that international humanitarian law applies to state actions in cyberspace. It is thus clear that there is no consensus on the applicability of IHL to the cyber domain. What qualifies as the use of force or armed attack has also not been settled in cyberspace. Equally challenging are the issues of attribution and judging legality of cyber attack as per principles of distinction, proportionality, necessity, and distinguishing between military and civilian targets. The international community has to agree on common definitions of cyber sovereignty, jurisdiction, conflict, cybercrime, deterrence, attacks, etc. India participated in the recently concluded first substantive meeting of the OEWG on September 2019 in New York. India endorses the need to have a common understanding on how international law is applicable to state use of ICTs is important for promoting an open, secure, stable, accessible, interoperable, and peaceful ICT environment. India hopes that discussions under UN and other multilateral fora will continue to study these issues with a view to promote common understanding on existing and potential threats in the sphere of information security and possible cooperative measures to address them. The development and implementation of cybersecurity laws, policies, and practices should be consistent with international law, including international human rights law. Keeping in view of these obligations upon the state, it is a need of the hour that states should have meaningful and constructive discussions on how international law applies to the state use of ICTs. In this regard, it is important to have regular institutional dialogue at the UN level as well as a regular dialogue at bilateral, regional, and multilateral levels. However, any such discussions here in ALCO and its working group should consider the work on the topic that is being conducted within the auspices of the United Nations with a view to avoid duplication of the work. Thank you, Mr. Vice President.
شكرا لممثل الهند. والآن مع كلمة ممثل جمهورية كوريا فليتفضل مشكورا.
Thank you, Mr. Vice President. With the remarkable advances in ICTs, we have seen the advent of a high-tech and interconnected world. It has presented us with a new domain of boundless opportunities, bringing unprecedented economic and social benefits. At the same time, however, the dual use of technology has brought about new security threats. Malicious actors are waging numerous attacks in the global cyberspace. In Korea alone, over 23,000 cases of malware attacks were detected every day in 2017. Such cyber attacks are not only increasing in number, but also becoming more sophisticated and threatening both in scale and impact. Cybersecurity cannot be single-handedly addressed by any one nation or actor. The global nature of the Internet requires international cooperation or even multilateralism. Therefore, we need to discuss mutual cooperation, assistance, and information sharing, and when doing so, we need to focus on the following critical elements. First, international norms to govern cyberspace offer a common standard for each state's behaviors, which helps to guarantee greater predictability. I believe the discussions in this session and the work of the ARCO Working Group on International Law in Cyberspace will further deepen our understanding of the current landscape of the normative framework for cyberspace and the challenges ahead. Second, practical measures designed for confidence and capacity building play a critical role in enhancing transparency and resilience in cyberspace. To enhance transparency and resilience in cyberspace more effectively, efforts to develop these measures should be made at national, regional, and global levels at the same time. The more we share knowledge and learn from each other, the clearer and stronger our posture becomes. In regard to these elements, the Republic of Korea is also actively participating on the discussions on cyberspace norms in the UN Group of Governmental Experts setting, as well as holding bilateral cyber policy consultations with 12 countries. The Republic of Korea has already submitted its answers to the questionnaire of the ALCO Open-Ended Working Group on International Law in Cyberspace. I hope this will deepen the understanding of cyberspace actors about cyberspace issues and promote cooperation between states. Thank you, Mr. Vice President.
شكرا لممثل جمهورية كوريا. والآن مع كلمة ممثل إيران فليتفضل.
Bismillah ar-Rahman ar-Rahim. Mr. Vice President, at the outset, my delegation would like to express its gratitude to the Secretariat for its continued work on the item International Law in Cyberspace and the background report. We would also like to praise the rapporteur of the working group, Professor Huang, for his continuous effort on the topic, especially for preparation of the questionnaire on cybercrime. Mr. Vice President, the Islamic Republic of Iran has attached great importance to the item International Law in Cyberspace since its inception in 2014. We followed with interest the development of the topic at ALCO, namely the establishment of the open-ended working group on international law in cyberspace that has held till now 4 meetings. We consider the working group a convenient platform for members to exchange ideas in a legal context and to contribute appropriate development of international law on cyber crime. During the 4th working group meeting, important issues concerning international law on cyberspace, including the crucial debate on international cooperation in combating cybercrime, application of the principle of non-intervention, and also issues related to data sovereignty were discussed, and my delegation has actively participated in the consideration of these issues. With regard to combating cybercrime, we actively participate in the relevant discussions within the context of the United Nations so as to come up with the universally negotiated and adopted instrument on combating cybercrime, taking into account the rapid changes and developments in this sphere. Domestically, the Islamic Republic of Iran has taken some important steps, including ratification of Cybercrime Act in 2009, Electronic Commerce Act in 2003, the law on publicizing and access to data on 2010, which provided legal ground in cyberspace. With regard to executive measures in fighting cybercrime, the government of Islamic Republic of Iran established Cyber Police in 2011 as an active organ in combating cybercrime. Of course, the efforts of our government has not limited only to domestic sphere. The relevant national authorities had considerable cooperation with their foreign counterparts. In this context, the Islamic Republic of Iran has also signed agreements and memorandum of understanding with different countries, particularly in our region, Western and Central Asia also. In this line, the Islamic Republic of Iran, in collaboration with the Interpol, hosted International Conference on Cybercrime in 2015 with participation of representatives from 15 states. Furthermore, the Cyber Police of Iran, responsible for ensuring cyber security in the country, has thus far launched joint missions with 111 countries and 200 executive bodies to confiscate fake drugs in the approximate value of $2 billion. With regard to the principle of non-intervention, I would like to emphasize that in light of fast technological advancements, respecting non-intervention principle is of great importance. This principle, as the right of every sovereign state to conduct its affairs without outside interference, is one of the fundamental principles of international law and principles set forth within the United Nations Charter. Although the importance and general status of the principle of non-intervention is uncontested, the exact dimensions and contours of application of this principle on cyberspace is not clear and need further work and deliberation. Mr. Vice President, we express our special thanks to the Secretary General for his valuable contribution and the proposal of the consensual basic principle of international law applicable in cyberspace, which was drafted based on the existing work of the rapporteur of ALCO working group and efforts within the United Nations. We also commend those governments that have provided their contribution. Iran will also present its comments on this draft in due course. We look forward to the next meeting of the working group to continue its work to fulfill its mandated task and to have its meaningful contribution to this important issue of the international community. I thank you, Mr. Vice President.
شكرا لممثل إيران. والآن مع كلمة ممثل الصين فليتفضل مشكورا.
Thank you, Mr. Vice President. Mr. Vice President, China advocates the principles of peace, sovereignty, shared governance, and shared benefits in international exchange and cooperation in cyberspace. The international community should work together to build a multilateral, democratic, and transparent global internet governance system. And we should strive for the building of a community of shared future for mankind in cyberspace. States generally agree that international law applies in cyberspace, but consensus has been absent in terms of how they apply. China supports the formulation of universally accepted international rules in cyberspace through multilateral and equitable democratic negotiations under the United Nations. In this context, we take note of the resolutions adopted by the 73rd session of the UN General Assembly, which decided to establish a new group of governmental experts and an open-ended working group. We hope that these two processes will yield positive results. The issue of combating cybercrime is of particular importance. Differences in law and practice among the states concerning criminalization, jurisdiction, and electronic evidence collection, among other things, have made international cooperation to combat cybercrime a difficult task. Recently, UN Secretary General submitted a report to the Third Committee of the UNGA on cybercrime, pursuant to the resolution adopted by the General Assembly in 2018. The report highlights the challenges faced by states in combating cybercrime. These challenges in combating cybercrime cannot be solved by a few regional conventions, including the Budapest Convention, which was concluded 18 years ago. We believe that the only effective solution is to collectively develop an international legal instrument that is negotiated by all states and is open to all states. China welcomes the work of the United Nations Intergovernmental Expert Group on Cybercrime in Vienna and fully supports the IEG to deliver concrete conclusions and suggestions on combating cybercrime before 2021. Recently, Russia, China, and a number of other states co-sponsored a draft UNGA resolution in New York requesting the General Assembly to establish an open-ended intergovernmental committee to elaborate a comprehensive international convention on combating cybercrime. We believe that, if adopted, the intergovernmental negotiation process set up by this resolution will provide an important platform for developing countries to participate in international rules-making process for combating cybercrime, rather than having to buy our tickets to be admitted to the club of a bloc of countries. We call on more countries to co-sponsor or support this draft resolution. China sticks to the principle of peaceful use of cyberspace and firmly opposes cyber warfare or cyber arms race. We call upon Asian and African states to work together to ensure that cyberspace becomes a new frontier for prosperity and development rather than a new battlefield. Without state practice, we should be very prudent on the discussion of application of humanitarian law in so-called cyber wars. The reason is very simple but fundamental. Firstly, no cyber wars shall be permitted, and secondly, cyber war will be a totally new form of high-tech war, giving the digital gap between the developing and the developed countries. Developing countries in general will be in a disadvantaged position in the discussion and development of such rules. It will be difficult to ensure that the rules are fair and equitable. Mr. Vice President, the ALCO Working Group on International Law in Cyberspace is an important platform. China supports the work of the working group and hopes that all ALCO member states will be able to benefit from the work of the working group. China is pleased to have had the opportunity to host the fourth meeting of the working group this past September. The deliberations of the working group cover a broad range of new and important issues in international law in cyberspace, including combating cybercrime, regulating online harmful content, and issues relating to transport data flow. We are hoping that the work of the working group will help us better prepare ourselves for the possible international rules-making processes under the UN. One important outcome of the fourth working group meeting is a consensus to draft a non-binding general document clarifying the consensual basic principles of international law applicable in cyberspace. We appreciate the guidance and work of the Secretary General in this regard and look forward to continue this discussion of these principles based on the valuable contribution from the Secretary General. We also note that the principles concerning transport data flow and the regulation of online harmful content are missing in the Secretary General's draft. We are hoping that the working group will incorporate these important aspects in the next iteration of the draft principles. Mr. Vice President, China hopes that ALCO can play a greater role in the development of international law in cyberspace. We will continue to support the work of the working group. We also call on all ALCO member states to actively participate in the discussion of the working group and enhance our capacity of cyberspace governance and rules making. I thank you, Mr. Vice President.
شكرا لممثل الصين. والآن مع ممثل أندونيسيا فليتفضل.
Thank you, Mr. Vice President. Mr. Vice President, distinguished delegates, ladies and gentlemen, my delegation would like to reiterate Indonesia's unwavering commitment in addressing cyberspace issues. The government of Indonesia has taken various important measures to promote peaceful cyber environment and economic growth through cyberspace. Peaceful cyber environment means respect to national sovereignty, protection of individual rights, and prevention of violations in line with global principles and norms. With regards to regulatory framework on cyberspace, Indonesia issued Law Number 11 of 2008 on the Electronic Information and Transaction, which then was amended by Law Number 19 of 2016. The government has issued Government Regulation Number 71 of 2019 on the use of system and electronic transaction. In addition to that, some regulations are being prepared, such as the Bill on Cybersecurity and Resilience, the Bill on Personal Data Protection. The government is in the final process of preparing a national strategy on cybersecurity. A number of regulations to combat conventional crimes using cyberspace have also been prepared. For instance, drugs-related crime, human rights violations, especially that involve children, child discrimination, exploitation, and violence, as well as for counterterrorism and violent extremism. Mr. Vice President, distinguished delegates, dynamic challenges on how to assure cybersecurity are confronting our world today. In this vein, strong commitment and collaboration among the international community, I believe, is a must. Indonesia, in principle, agrees for the adoption of the 11 cyber norms on responsible state behavior in line with the 2015 UN Group of Governmental Experts report. Indonesia encourages the need for establishing global principles and norms with a view to formulating global principles and norms to developing global architecture in cyberspace in various forums. Both the UN and ALCO through multi-stakeholder approach to develop tolerant and inclusive cyberspace. Developing open, free, and safe cyberspace for peaceful purpose with respect to state sovereignty and human rights through inclusive participation and the use of diplomatic solutions and the avoidance of military force in resolving cyberspace conflict. In addition to that, countries are obliged to take best efforts in dealing with challenges of cyber crime, especially terrorism in cyberspace. Indonesia is currently formulating a national action plan on countering extremism that leads to terrorism. This plan of action is aimed at preventing the use of cyberspace as well as social media platform for radical terrorism activities and its financing. Indonesia extends its sincere gratitude and appreciation to the effort of the fourth meeting of the ALCO Open-Ended Working Group on International Law in Cyberspace that presents consensual basic principles of international law applicable in cyberspace. Indonesia takes note to the result of the working group. Indonesia considers positively consensual basic principles of international law applicable in cyberspace as recommended by the working group. However, concerning the point on states' obligation to cooperate in regulating military use of cyberspace, my delegation is of the view that this matter needs further discussion, as we believe this point is under the realm of military, which is supposed to be discussed among themselves, such as through the forum of defense dialogue, etc. On this important issue, Indonesia would like to encourage ALCO to establish ALCO Point of Contact Directory consisting high and working level. The point of contact shall coordinate and confirm when cyber incidents occur. To support social media companies to assist governments of ALCO member states in filtering the spread of negative contents on terrorism, pornography, including child online protection, on discrimination, exploitation, and violence, and other cyber crime-related matters. To enhance public-private partnership through building collaboration to prevent misuse of Internet. Mr. Vice President, distinguished delegates, with regard to questionnaires submitted by the working group, we are still working on it and will submit our response at the earliest time. Indonesia supports and is open for further discussion on the issue of cyberspace. In closing, we look forward to a productive and substantive exchange of views among distinguished representatives on this issue, with a view to exploring the needs for various means in identifying gaps as well as addressing the way forward for further actions to effectively enhance cooperation in addressing the threat of cybercrime and to protect our society from falling prey to cyber crimes. I thank you, Mr. Vice President.
شكرا لممثل أندونيسيا، وباسمكم جميعا نشكر رئيس المنظمة، وبعد استئذانه سأكمل الكلمات لممثلي الدول. والآن مع كلمة ممثل فيتنام، فليتفضل مشكورا.
Mr. President, my delegation would like to join with other delegations to express our concern on the application of international law in cyberspace, as cybersecurity has increasingly become a global issue that deserves our utmost attention. As the fourth industrial revolution is nearing, every one of us has never been more exposed to the pros and cons of technology. States are no exception. We are facing unprecedented problems as ICT technology has posed unforeseeable security risks, from spreading harmful or malicious contents, conducting spontaneous and individual acts for illicit personal gains, to aiming attacks at the cyber environment. malicious cyber activities such as fake news have now expanded in scope, are becoming transboundary in nature and adversely affect the socio-economic stability and national security of many states. For the past few years, Vietnam has frequently suffered from fake news and cyber attacks, threatening the national security and causing loss to state entities and nationals. The lack of a universally accepted set of norms to govern activities in the cyberspace, as well as the diverse points of views on the application of established international law in the cyberspace, calls for immediate actions from states to prevent the unpredictable threats to security on national, regional, and international levels. Thus, Vietnam truly appreciates the constant efforts of ALCO to initiate and maintain the substantive discussion on the matter. It has created a forum for the members to put forward their perspective, share their national experiences, and bridge their differences in order to join efforts against the common threats of cyber criminals. From these cooperation activities, a general practice may emerge and lay foundation for the creation of norms in the governance of cyberspace. Enhancing cybersecurity within the territory of Vietnam has been one of our priorities. Following the comprehensive law on cybersecurity enacted in June 2018, a governmental decree detailing the implementation of the law is now being built and substantially governs the entire cybersecurity of the nation and seeks to combat cybercrimes, protecting not only government assets, but all those that are critical to stability, security of the country. So far, Vietnam has yet become a party to any international convention on cybercrime or cybersecurity, while still in the process of studying this evolving concept, gradually improving our national legal framework in this area with a view to ensuring its compatibility with the current relevant international norms and standards. Therefore, Vietnam has been looking forward to discussion at both international and national levels with all states and partners on the understanding of cyberspace-related issues in relation with well-recognized principles of international law and conventional norms such as territory, boundaries, or armed attack. Without international cooperation, a common understanding of how international law applies in the cyberspace could hardly be obtained. With such understanding, Vietnam and other members of ASEAN have been exchanging views on different levels on combating transnational crimes, including cybercrimes. Cybersecurity is now one of the notable items on ASEAN meeting agenda, calling for attention, participation, and cooperation from the members. Aside from Vietnam, some members have also adopted significant legal instruments regulating conduct on cyberspace. In 2020, as the chairman of ASEAN, Vietnam would continue to foster the mutual efforts to deepen the discussion on combating cybercrimes and ensuring peaceful and safe cyberspace, as well as to harmonize the domestic regulation, expecting to contribute to a universally accepted understanding and set of norms. Regarding the report prepared by the ALCO Secretariat, contained in the document named International Law in Cyberspace, this delegation would like to applaud the work done by Professor Huang, rapporteur of the ALCO Working Group on International Law in Cyberspace, as well as a contribution by every member of the working group. Aside from the topic of combating cybercrimes, the latest discussion in Hangzhou in September has brought into light some significant issues when it comes to applying established principles of international law in the face of newly formed practices. Vietnam holds the view that international law, especially principles set forth by the UN Charter, shall be applicable to cyberspace, Accordingly, states must also use the cyberspace peacefully and refrain from using or threatening to use cyber attacks in international relations. However, as cyberspace is an evolving phenomenon, we should draw lessons from other domains such as outer space and the law of the sea. Besides, international community should take into consideration the interests of developing countries, allowing them to take the most advantage of technology while building a safe and peaceful cyberspace. Although the delegates hardly reached an agreement during the working group meeting, we believe that exchanging views is the only way for states to deepen mutual understanding and to come up with a resolution. We therefore fully support the enhancement of ALCO member state cooperation in countering cyber crimes by continuing discussion on some key issues of international law in cyberspace. Last but not least, our delegation would like to thank the Secretariat for preparing the draft consensual basic principle of international law applicable in cyberspace. The document certainly reflects our common expectation to have a set of principles governing acts on cyberspace. However, the topic requires further study and should not be rushed for the purpose of adopting an outcome document. As a perspective remains divided at present, this draft was not based on a sound legal argument and is more of political nature than of the legal one. It should be elaborated if the draft principle aims to analyze or develop the acknowledged principle of international law. Most of all, the fundamental elements of military activities, such as armed attack, use of force, self-defense, or hostility, ought to be carefully examined in the context of cyberspace before arriving at a principle of applying the international law governing the armed conflicts in cyberspace. I thank you for your kind attention, Mr. President.
شكرا لممثل فيتنام. والآن مع كلمة ممثل المحكمة الجنائية الدولية فليتفضل. الآن مع كلمة اللجنة الدولية للصليب الأحمر فليتفضل ممثل اللجنة. آسف جدا على الترجمة.
Thank you very much, Mr. Vice President. Mr. Vice President, Mr. President, Mr. Secretary General, distinguished delegates, thank you for providing the International Committee of the Red Cross the opportunity to address the topics of international law in cyberspace to this distinguished audience. As already mentioned in our statement delivered yesterday by the head of the ICRC mission here in Tanzania, in view of the mandate that the international community gave us, our focus is on the limits that international humanitarian law, or IHL, impose on the use of cyber operations during armed conflict. Mr. Vice President, distinguished delegate, today, cyber operations are being used as means and method of warfare in ongoing armed conflicts. Australia, the United Kingdom, and the United States have officially acknowledged doing so, including in the territory of some ALCO member states, according to US official statements. Cyber operations have also been used in other countries that are involved in an armed conflict, otherwise waged with traditional means and method of warfare. This was the case during the international armed conflict between Russia and Georgia in 2008. Cyber operations also affected the delivery of essential services such as electricity, or otherwise negatively affected businesses more recently in Saudi Arabia and in Ukraine, two countries involved in non-international armed conflict. The perpetrators of these cyber attacks remains unknown and attribution of responsibility is contested. At the ICRC, we are concerned with the potential human cost of cyber operations during armed conflict. And I mean the risk of causing deaths, physical damage, or disruptions of essential services to the civilian population. We are also concerned because we are a user of cyberspace and we have also been the subject of cyber attack. With the support of cybersecurity and cyber threat intelligence experts, we published a report on the potential human costs of cyber operations earlier this year, which is available on our website. In our view, it is critical that states affirm that international humanitarian law limits the use of cyber operations during armed conflicts and protect civilians and civilian objects like it does with any other means and method of warfare. What does it mean that international law applies in cyberspace? It means that under existing law, among many other rules, indiscriminate cyber means are prohibited. That cyber attacks against civilians, indiscriminate cyber attack and disproportionate cyber attacks are prohibited. That the delivery of medical services must be protected and respected, including when carrying out cyber operations during armed conflict. It is prohibited to render useless objects indispensable to the survival of the population, including through cyber means. And the list goes on of the protection that international humanitarian law affords to civilians against the effects of hostility. What the application of international humanitarian law does not mean is that it does not legitimize conflict, neither in the traditional domains of warfare nor in cyberspace. This is governed by the UN Charter, which applies in cyberspace as noted by the UNGG in its 2013 reports and by several distinguished delegations today. In cyberspace, as in any other space, the threat or use of force is prohibited and international disputes must be settled by peaceful means, a topic on tomorrow's agenda of this annual session. To assert that international humanitarian law applies does not encourage the militarization of cyberspace either. On the opposite, it imposes limits on military cyber capabilities that states could develop. Of course, states may decide to impose additional limits to those found in existing law, for example, to ensure a stable, secure, and peaceful cyberspace, or as recommended by the distinguished delegates of China earlier, to avoid an arms race in cyberspace. Mr. President, distinguished delegates, when an armed conflict unfortunately breaks out, we at the ICRC witnessed firsthand the immense suffering and extensive destruction caused by hostilities. What international humanitarian law provides is an additional layer of protection and a sense of humanity in the midst of suffering. There is no doubt in our view that this protection limits the use of cyber operations during armed conflict because it applies to all future, because our international humanitarian law applies to all future war and all future means of warfare as noted by the International Court of Justice in its advisory opinion on nuclear weapons. We therefore welcome that since several years, ALCO and its open-ended working group, including the study of international humanitarian law in its work. As a tangible outcome of the work of the open-ended working group, the Secretary General put forward for consideration of ALCO member states consensual basic principles on international law applicable in cyberspace. Let me applaud the work of ALCO Secretary General and its Secretariat, ALCO Open-Ended Working Group and its rapporteur, and all ALCO member states concerned that led to such draft principles. They cover a broad range of key issues. In view of the consideration I mentioned above, we of course welcome the inclusion in paragraph 2H of a provision addressing the military use of cyberspace and aimed at ensuring respect for international humanitarian law. Mr. Vice President, distinguished delegate, as noted by the distinguished delegates from Nepal and from China, there is today general recognition that international law applies, and the discussion has moved forward towards how it applies. With regard to international humanitarian law, however, as the distinguished delegates from India noted, there is no clear consensus today on its applicability, despite the fact that the UNGG report in 2015 noted as applicable the principle of necessity, humanity, distinction, and proportionality. By adopting a principle aimed at ensuring respect for international humanitarian law, ALCO would substantially contribute to progressing the international conversation towards reaching consensus on this issue. We therefore strongly encourage ALCO member states to continue to study how international humanitarian law restricts the use of cyber operations during armed conflict. Determining how international law, including IHL, applies to cyberspace is a shared responsibility among the international community. Every state, big or small, including those that would not consider developing cyber capability, may become the direct or incidental victim of cyber operations. Therefore, every state may have an interest to express its view on how international law, including IHL and the law of neutrality, protects them and their population against the effects of cyber attack during armed conflict. True, of course, the unique characteristics of cyberspace raise several critical questions about the interpretation of IHL rules. Take the example of a cyber operation that would render critical civilian infrastructure dysfunctional without causing physical damage. Is it an attack on the IHL? This would mean that it is clearly prohibited to direct it against a civilian critical infrastructure. Or because there is no physical damage, would it be an operation other than an attack, in which case it's governed by less precise and less stringent rules? In our view, of course, this is an attack under IHL, so I mean when an armed conflict is ongoing. And it is a prohibited attack when directed at civilian infrastructure. But of course, it is for states to address these questions. Mr. President, distinguished delegates, affirming that international humanitarian law applies in cyberspace and discussing how it must be interpreted does not imply that new rules might not be useful or even needed. As with the development of any new weapons, means or method of warfare, states may agree upon further rules to prohibit or limit specific military cyber capabilities or specific operations for a range of reasons, including humanitarian reasons. If new rules are developed, they should build upon and strengthen existing law. In the meantime, as underscored by the distinguished delegates of Tanzania, cyberspace is not a lawless area. The development of military cyber capabilities and their use during armed conflict is already constrained by existing international law, including international humanitarian law. Mr. President, distinguished delegates, I thank you for your attention.
لممثل اللجنة الدولية للصليب الأحمر، والآن مع كلمة ممثل روسيا فليتفضل.
Thank you, Mr. Vice President. My statement will consist of two parts. First on application of law, second on cybercrime, exactly the areas of ALCO interest. At first glance, the question of the applicability of international law to ICT doesn't seem to be complicated. International law regulates the activities of subjects of international law, primarily states. Based on this, its norms should be applied in any field where these subjects operate. This general conclusion regarding the applicability of law found overall support within the framework of the group of governmental experts on development in the field of information and telecommunications in the context of international security in 2013 and 2015. This conclusion was also included in the resolution of the General Assembly 73/27. However, if we try to look behind these statements, the issue becomes more complicated. Since the adoption of the latest report of the group of governmental experts in 2015, the discussion has not progressed significantly. What are the reasons? First of all, is the divergence in the approaches of different groups of states. One group, to which Russia belongs, strives to develop legal aspects of the peaceful use of ICT, including practical issues of protecting the sovereign equality of states, non-interference, and cooperation in the use of ICT, while some others put on top the analysis of military use of ICT, including the applicability of Article 51 of the UN Charter and the right of self-defense. Mr. Vice President, the possibility of applying the right of self-defense in response to an ICT attack has already been reflected in the national military doctrines of states and in the final declarations, for instance, of NATO summits, in particular in Wales and Warsaw. The Group of Seven also supported this position, which was reflected in the document called G7 Principles and Actions on Cyber. The same group of countries intends to secure the right to apply countermeasures in response to cyber attacks while avoiding or directly refusing to discuss the problem of establishing a relationship between the attack and the corresponding state, as well as the problem of establishing standards of proof for such a connection and the damage caused. There is also a group of countries that are most interested in promoting the principle of due diligence in its broad interpretation, according to which, in fact, any computer attack from the territory of the state should lead to the international legal responsibility of this state, even if the connection between the harmful use of ICT and the state is not apparent. We believe, however, that the question of the standard of proof and the attribution of the computer attack to the state in order to establish its international legal responsibility should precede any lightweight generalizing conclusions about whether any countermeasures can be taken in response, and even more so if Article 51 of the UN Charter is. Thus, we return to the issue of the practical applicability to ICT of the universally recognized principles of the non-use of force, which has the status of a peremptory norm of international law. Could any cyber attack, even with serious consequences, constitute an armed attack or other unlawful use of force from the viewpoint of the UN Charter? In this context, one cannot help but recall statements of some states that they were victims of hacker attacks, which supposedly can be attributed to a certain state. At the same time, no evidence is presented to support such allegations. History is rich of examples of wars that began with armed provocations. Recognizing certain types of hostile use of ICT as an armed attack, which gives the right to reciprocal use of force, can plunge the world into chaos with unpredictable consequences. In the same context, the general recognition of the applicability of international humanitarian law to the use of ICT is a tricky question. Even the ICRC, one of the main supporters of recognizing the applicability of IHL to ICT, in its 2014 study acknowledged that in practical terms, applying the key principles of distinction between military and civilian infrastructure and proportionality to ICT will be difficult, if not impossible. Based on this understanding, it seems that the most promising, indeed, is the topic of practical application of the principle of peaceful cooperation in the field of ICT. This principle could be the key in this area. The principles of responsible behavior set forth in the already mentioned resolutions of the General Assembly on the developments in the field of ICT can be considered one of the forms of the implementation of this principle. The GA resolution expressly notes that, and I quote, the United Nations should play a leading role in promoting dialogue among member states to develop common understandings on the security of and the use of ICTs, as well as in developing common understandings on the application of international law and norms, rules and principles for responsible state behavior in this sphere, end of quote. Bringing the dialogue to the UN is important for building international consensus in this field. Regionalism in these matters may turn out to be dangerous. The resolution of the GA goes further and reaffirms the right and duty of states to combat within their constitutional prerogatives the dissemination of false and distorted news, which can be interpreted as interference in the internal affairs of other states or as being harmful to the promotion of peace, cooperation, and friendly relations among states and nations. And vilification of hostile propaganda for the purpose of intervening or interfering in internal affairs of other states. We believe that this provision is one of the key provisions in the resolution, and practical measures for its implementation should be discussed. It seems that it would make sense to consider the possibility of exchanging information between states regarding messages originating from the territory of a foreign state that explicitly aim to overthrow the legitimate governments of other states. The question of how states could cooperate in preventing the spread of malicious information is one of the most complex and controversial issues, on which there is also a traditional split in the opinions between states. On one hand, international law knows a number of prohibitions of propaganda. On the other, prohibitions on the dissemination of certain information on the internet should be adopted in accordance with human rights obligations. However, this doesn't negate the fact that in this area there is still much room for further cooperation between states. I would like to underline that the problem of the scope and specific forms of applicability of international law to the use of ICT cannot be solved just by extending certain international obligations to the ICT sphere. Currently, priority should be given to the commitments of states on the implementation of the principle of cooperation in the field of ICT, which can significantly narrow the field for controversy surrounding the issue of use of force and Article 51. Mr. Vice President, the second issue I would like to comment is cybercrime. We see a lot of potential for cooperation here. The problem of the use of ICTs for criminal purposes has become a truly global one, and the damage of the world economy from this threat is growing. The cybercrime, including the information theft, hacking on the web, gradually turns into a kind of industry. Dark web is actively used by terrorist groups and by criminals for illicit trade in drugs. The existing regional criminal law mechanisms contribute to counter these threats, but they do not adequately cope with them. It was already highlighted today with regard to the Budapest Convention. They are often incompatible with each other. At the same time, states, regardless of their level of development, cannot effectively deal with criminals without proper international cooperation. We think the situation is complicated by the lack of a comprehensive international legal framework. In this context, there is indeed a need for an international binding instrument under the auspices of the United Nations. It was already highlighted today by Professor Lukumei. This instrument is, in our view, we should base this instrument, in our view, on the principles of sovereign equality and non-interference. The objectives might be as follows. Firstly, to promote and strengthen measures to prevent crime and other illegal acts. Secondly, to ensure the prosecution of such acts, facilitate the identification and investigation of such acts, and thirdly, to increase the efficiency of international cooperation, including training and technical assistance. In this regard, a solid group of co-sponsors, including Russia, China, and a number of other states present in this room, has drafted the UN General Assembly resolution entitled Countering the Use of ICT for Criminal Purposes, which on one hand makes it possible to build on the discussions of this issue held in the UN General Assembly this year, and on the other hand creates a negotiating platform which may be used in the long term. It is important to take a step forward and move to practical arrangements. Mr. Vice President, we would appreciate if you and others in the room could support this draft resolution and become its co-sponsors. The co-sponsorship list is now open in New York. Thank you for your attention.
شكرا لممثل روسيا. والآن مع كلمة ممثل عمان فليتفضل مشكورا.
معالي الرئيس، فيما يتعلق بموضوع القانون الدولي في الفضاء السبراني، فإن سلطنة عمان تود بداية أن تعرب عن شكرها وتقديرها للجهود القيمة التي تبذلها الأمانة العامة للمنظمة وفريق العمل المفتوح العضوية في مجال الفضاء السبراني. كما تعرب سلطنة عمان عن توافقها مع ما خلص إليه فريق العمل في اجتماعه الرابع المنعقد في مدينة هانغزو بالصين خلال الفترة من 2 إلى 4 من سبتمبر 2019 ميلادية بشأن أهمية التعاون بين الدول الأعضاء في مجال مكافحة الجرائم السيبرانية والمسودة التي أعدها الأمين العام حول مبادئ القانون الدولي التي تنطبق على الفضاء السيبراني، مشكلة بذلك اللبنة الأولى التي يمكن للدول الأعضاء
applicable on cyberspace. This forms the cornerstone or the foundation on which the countries of the world can build on and deal with in order to develop a common and unified position which can be debated in international and fora. We also welcome any initiatives which may be discussed in this regard in order to achieve our objective. We know that our country I want to tell you that my country attaches great importance to this subject, and we have tried to develop legislations on cyberspace at the national level, and also we have tried to create mechanisms that are very helpful in our country.
ولما كان هذا الفضاء يزداد تمددا
since the cyberspace has been increasing and expanding day by day, and it has become transnational in nature, and there have been uses by unpleasant uses and, which are affecting the sovereignty of the states and their security and economic stability, and which has become evident for everybody. All countries have no choice except to cooperate among themselves and develop a legal regime which may govern the processes of the transit and the content and the malicious use of the cyberspace. And we are that the efforts put in by this organization in this regard will definitely contribute to achieve our end. Thank you very much, and we thank the open-ended working group. Thank you. Shukran, the representative of Oman. And I thank everybody
ممثلي الوفود على
for their legal studies and their inputs that they have shared with us on cyberspace. And also thank professors with me on the dais. Now we'll break up for 15 minutes and we will resume the discussion of law of the sea. Thank you very much.